What is a court-ordered ISP in Creek County? In Creek County juvenile and child welfare cases, a court-ordered ISP usually refers to an individualized service plan ordered through the Oklahoma child welfare system and overseen by the court. These plans commonly arise in cases involving the Oklahoma Department of Human Services, OKDHS or DHS, deprived child proceedings, emergency custody matters, abuse or neglect investigations, or efforts to reunify children with parents. What is an individualized service plan? An ISP is one of the most important documents in a DHS case because it outlines the specific actions a parent or guardian must complete to address the concerns that led to DHS involvement. Failure to comply with the ISP can have serious consequences, including prolonged DHS supervision or, in extreme cases, termination of parental rights. An ISP is a written plan developed by DHS that identifies the problems or conditions leading to the child welfare case, the services required for the parent or family, the goals DHS expects the parent to achieve, and the permanency plan for the child. Under Oklahoma law, DHS must prepare and maintain a written ISP for children adjudicated deprived. The plan is individualized for each family and is supposed to be realistic, measurable, and tailored to the child's safety and well-being. Why would a court order an ISP in Creek County? ISPs are commonly ordered after allegations of abuse or neglect, emergency removal of children from the home, DHS investigations, juvenile deprived proceedings, and findings that the child's safety may be at risk. The court typically reviews and approves the ISP during juvenile court proceedings. Once approved, the ISP may be included in the court's dispositional order. What can be included in an ISP? The exact requirements depend on the circumstances of the case, but an ISP may require parenting classes, drug or alcohol treatment, counseling or therapy, mental health evaluations, drug testing, stable housing requirements, employment requirements, supervised visitation, and domestic violence counseling. The ISP also often includes visitation schedules, deadlines, progress requirements, and regular review hearings before the court. Parents usually participate in developing the ISP. Oklahoma regulations state that the ISP is developed with participation from the parents or guardians, attorneys, DHS workers, the child when appropriate, and tribal representatives if applicable. If portions of the ISP are disputed, the court may hold an evidentiary hearing to determine the final terms of the plan. What happens if you fail an ISP? Failure to comply with a court-ordered ISP can create major legal problems. Possible consequences may include extended DHS involvement, delays in reunification, continued removal of the child from the home, more restrictive visitation, and the termination of parental rights proceedings or the parent being unfit. DHS and the court will often monitor progress closely through periodic review hearings and ISP progress reports. Can you challenge an ISP? Yes. Parents are generally allowed to challenge portions of an ISP or argue that certain requirements are unreasonable, unclear, unsupported, or impossible to complete. In some cases, attorneys may argue the ISP requirements are unrealistic, DHS failed to provide services, the parent substantially complied, and the allegations leading to DHS involvement are disputed. Because juvenile proceedings can move quickly and directly affect parental rights, legal representation is extremely important. Creek County Child Custody Attorneys. Court-ordered ISP cases in Creek County are serious matters that may ultimately affect custody, visitation, and parental rights. Many parents underestimate how important these proceedings become until the case progresses toward permanency hearings or termination proceedings. Because DHS proceedings involve strict deadlines, recurring hearings, and long-term consequences for families, individuals facing a court-ordered ISP should seek experienced legal guidance as early as possible. Our child custody team at Creek County Attorneys can help you and will provide the best possible legal strategy for your case. Call us at 918-209-3709 for a free and confidential consultation.